I have a class on UPOV, that is normally spelled as UPOV, and PPV and FR Act. So these are the two ways of protecting our plant varieties. Today we are going to study about these two topics. Firstly, coming to UPOV. UPOV is abbreviated as International Union for Protection of New Plant Varieties. The only intergovernmental organization which is concerned with the protection of new plant varieties, and then the headquarters of which are situated at Geneva, Switzerland. It is meant to protect new plant varieties, and it was signed in Paris in 1961 and it has entered into force in 1968. The UPOV aims to ensure the protection of plant breeder rights, mainly plant breeder rights, and this is a grant of an exclusive right which is meant for protection of the new plant varieties on the basis of the set of uniform and clearly defined principles developed by UPOV. Then what are the basic functions of UPOV? The convention has two main functions. First one is to prescribe the minimum rights that must be provided to the plant breeders by the member countries. In other words, it specifies a minimum scope of protection. And second is to establish a standard criteria for grant of the protection for these plant varieties. Then under UPOV, a plant variety is said to be qualified for protection when it is said to meet following criteria, which are termed as NTUS. So the first one, distinctness. So it should be a distinct one from the existing commonly known varieties by at least one or more identifiable characters, which may be morphological or physiological or any other kind of character it may be. Then novelty. So it should be a new one in the commercial sense, that it must not have been commercialized prior to the certain date which was established by the reference to the date of application. Then uniformity, that is, it should be sufficiently homogeneous or uniform in its appearance at a said specified environment. And finally, it should have stability, that is, a stable appearance and its characteristics over environment in successive generations under the specified time. And a unique and unambiguous means it should not be a confusing type of denomination, that is nothing but a name of a variety. So these are the criteria that should be met for qualifying a variety. Then how to and how long it is protected. So application can be filed in the country where it is developed or in any other UPOV member country. As per 91 Act of UPOV, such protection is said to be granted to the varieties of all the genera and species of the plants for a period of 25 years for trees and vines, and rest of the other plants it is 20 years. The protection granted for a new variety authorizes the breeder the exclusive right to commercially exploit that variety by direct sale or by licensing to others for sale. Then there is a provision called as breeder's exemption. So under this PBR regime, the use of the material of the protected variety for development of the new variety is exempted from protection. So what it means? That means that the PBR for these new varieties will be of the breeder who developed them, and the holder of the PBR title of the initial variety will have no claim to it. So this provision is called as breeder's exemption. So, and there is a change in this. Under UPOV 1978 Act, all the new varieties evolved during the using a protected variety were exempted from this protection. That is, so if you are using certain variety and trying to improve that variety, then the new variety which is improved one is also being protected. Then under UPOV 91 Act, this provided limited the scope of breeder's exemption by bringing the essentially derived varieties under the cover of PBR protection granted to the initial variety. So what are these essentially derived varieties? Say for example, there is one variety of rice which is susceptible to a particular disease. Then if the person is trying to introgress one gene which is governing resistance to that disease, so the variety is alike when compared to the previous one, but it is having a certain new, a single new gene combination because of which it is providing resistance. So that one is referred as an essentially derived variety. So what the consequence of UPOV 91 Act is that a breeder who insert a single gene, example as disease resistance gene, into a protected variety will now have to obtain the permission from the original right holder before marketing that variety. So that has limited the scope of essentially derived varieties under UPOV 91 Act. Then there is one more provision which is a farmer's privilege under UPOV system. So PPR system generally allows farmers to use the material of the protected variety which is harvested in their own farm for planting of the new crop without any obligation to PBR title holder. So this exemption is farmer's privilege. Under UPOV 1978 Act, there was explicit provision for this farmer's privilege. But coming to 91 Act, this privilege has been optional and each UPOV member state can either allow it or disallow the privilege. Then UPOV 91 Act deprives the farmers of its rights to use and reuse their seed as their produce as a seed. So it should be clearly understood that farmer's privilege applies to the use of the seed produced by farmers for sowing his own fields. PPR, however, does not allow farmers to exchange the plant varieties produced on their farms. Then, two sides of UPOV. Several developing countries are following the UPOV system. Those joined before 1999 could join under less strict UPOV Act, that is 1978 Act. So 1978 Act, which confers. So the best example is China here, but the countries that join now have to do that under the UPOV 91 Act. So examples are Korea, Singapore, and Vietnam. So most of the developing countries have opted for development of their own sui generis system. So India and Thailand has enacted a sui generis system of plant varietal protection known as PPVFR Act 2001 and PVP Act 1999 respectively. So India has developed PPVFR Act 2001. Similarly, Thailand has evolved PVP Act 1999. So acts of these both of these countries are TRIPS compliant. That means it satisfies the TRIPS conditions. So here is a world map which shows how much of the UPOV following states or countries are distributed across the world. So if you observe this, North America and South America are entirely having control over UPOV, are under the control of UPOV, whereas Europe majority is under control of UPOV, and Africa it is partially, and India is totally not under the control of UPOV. Then Australia is under UPOV again. So majority of the part is under UPOV. Then two dimensions of world's agriculture. So there are two dimensions of agriculture across the world. For most of the members of UPOV, agriculture is nothing but a commercial activity and supply of the seeds is under the control of the corporate sectors. For majority of the Indians and also countries like Pakistan, Thailand, Indonesia and Philippines, agriculture is a livelihood and farmers are the principal source of seed supply. Then coming to plant varietal protection in India. As stated previously, the Protection of Plant Varieties and Farmers' Right Act 2001 was developed as a part of sui generis system evolved as per TRIPS agreement. India is a statutory to World Trade Organization agreements and ratified the agreement on TRIPS. So as per the Article 27.3b of the TRIPS, which demand the member countries should protect their plant varieties either by a patent or by an effective system of sui generis, or they can also opt a combination of these two. So in this context, India chose a sui generis system for protection of plant varieties. Sui generis system, what the meaning of this is, it is a system of its own. So we evolve our own system of protecting our plant varieties. An act named as Protection of Plant Varieties and Farmers' Rights PPVFR Act 2001 has been passed by the Parliament on 8th August 2001 and rules have been framed in 2003. The authority has been constituted PPVFR Authority with its head office located at New Delhi. Then the PPVFR Act is a TRIPS compliant and compatible with UPOV system of the plant protection and varietal protection. Then what is the status of India as far as UPOV is concerned is it is having or holding an observer status. Then PPVFR Act 2001 provides protection to the following varieties: newly bred varieties, extant varieties. So newly bred varieties are newly evolved ones or newly developed ones, and the extant varieties are those which were released under Section 5 of Indian Seed Act, have not completed 15 years and have as on the date of application of their protection. So these have not completed 15 years. So all those varieties are treated as extant varieties. And then farmers varieties. So the varieties which have been traditionally cultivated from years together, including land races and their wild relatives, which are in common knowledge evolved by the farmers. These varieties are well known from years together or from generations together. Then what are these essential derived varieties? Essentially derived variety is a variety that is predominantly derived from an initial variety and retains all the essential characters of that later, while in as well as those rules having limited differences to the qualify distinctiveness from an initial variety. As stated earlier, if you are incorporating a gene for resistance in an existing variety and trying to improve it and trying to go for a protection of that variety, that may be treated as essentially derived variety. So the best example for that is improved Samba Mashuri. Samba Mashuri is well known, which was developed by Angrao at that time. Then it was improved by Indian Institute of Rice Research, Hyderabad, for BLB resistance, and that is titled as essentially derived variety. Then transgenics. So transgenics is these varieties are those which are developed by transfer of the genes from unrelated organisms. Then registration under PPVFR Act. So an application for registration can be made by any person claiming to be a breeder of that variety, who is a successor of the breeder, or an assignee, or any farmer or group of community of farmers, or any person authorized for the above mentioned categories, or it may be any university or publicly funded agricultural institution claiming to be the breeder of that variety, can go for application of the PPVFR. It is pertinent to note that Act under breeder recognizes farmer as a cultivator, conserver, or landless, male and female. This embraces all the farmers, landed or landless, male or female. To qualify for the registration under this act, a new variety has to conform the following criteria, the same which is similar to that of UPA, whereas the four characters are novelty, distinctness, uniformity, and stability. Besides, it should have a denomination for a registration of a variety. So that is nothing but a title of the variety or a label of that variety. So first coming to novelty. Here novelty, these terms are defined in a different way when compared to UPA. So novelty. A variety is deemed novel when it has not been placed for commercial use in India for a period not exceeding 12 months if bred in India. Then the varieties which are bred outside, what is the case in that is India is deemed to have novelty if its protection is sought within a period of not exceeding 4 years of time in case of annuals and 6 years in case of vines and trees from the date of registration. Then distinctness. So the candidate variety should be different from other varieties for of the common knowledge, at least for one character. Then uniformity. It means the phenotypic similarity among the plants subjected to variation that may be expected and allowed due to a specific nature of reproduction of the crop, such as it may be vegetative, self or cross-pollinated things. And hybrids are to be treated as self-pollinated plants while looking for this uniformity aspects. Then coming to stability, it is the essential characteristics that remain unchanged after the repeated propagation. Then there are few clauses here for extant and farmers varieties which are in the public domain in the dust features will be considered while novelty feature is exempted because these varieties are not new and are in the public domain already. And in this act, a special clause has been put in which it states that a variety with terminator gene sequences will not be registered. That is, any transgenic material with GERT, that is genetic use restriction technology sequences, will not be registered. So you may be aware or not. So I will brief on these aspects. So if the seed material cannot be used again and again, or if there is a sequence that allows for only single crop, and the next season the seed cannot be used as a propagating material, so that is treated so because of a sequence which kills the embryo, that is referred as termination gene sequence or GERT sequence. Then progress of PPVFR in India. All the varieties will be registered with PPVFR. So dust guidelines have been framed for 35 crops right now, have been prepared with by the ICAR, while the dust guidelines for 18 crop species have been notified by the PPVFR authority as well in the Gazette as a plant variety journal of India. Then the PPVFR authority has established testing centers for each of the variety crop species, and authority has started registration of the varieties for 12 crops of the cereals and legumes and 6 crop species of jute and cotton. Then the registration will be extended to 35 crops that include pulses, oilseeds, vegetables, and also 2 flower species. And dust guidelines are also being prepared for medicinal aromatic plants, spices, or ornamentals, and forest trees, for which these task forces have been constituted by the PPVFR. Then duration of validity of the certificate of registration for a variety. So in case of trees and vines, it is valid for 9 years initially, and it is renewable up to 18 years. Whereas for other crops, it is initially valid for 6 years and it is extended by renewal up to 15 years. So in case of extant varieties, the validity period is 15 years from the date of notification of that variety under Section 5 of Indian Seed Act. Then coming to compulsory licensing. So as a provision for compulsory license has been put in this PPVFR Act. According to this, after expiry of 3 years of time from the date of issue of the certificate of registration of a variety, any person who is interested can claim in the application to the authority alleging that the reasonable requirements of the public for the seed or any kind of propagating material has not been satisfied, or the seed or the other propagating material is not available to the public at a reasonable price, and then pray for the grant of compulsory license. So based on that, he may be allotted to undertake the production, distribution, and sale of the seed or the propagating material of that variety. Then Protection of Plant Varieties and Farmers' Rights Act authority. It was established by Central Government of India. Duty is to promote development of the new varieties of the plants and to protect the rights of the farmers and breeders It will establish a plant varieties registry for registration of the plant varieties. The register shall maintain a national register of plant varieties with the following details at the registry head office. So, name of the registered plant variety, name and breeder's address, the right of the breeder in respect of the variety, denomination, particulars of the variety, then seed or other propagating material, specifications or silent features, and other prescribed matters. The breeder shall be required to deposit specific quantities of the seeds or propagales of the registered variety as well as its parental lines in the National Gene Bank as specified by the PPVFRA. Then there are few provisions under this PPVFRA. These are researchers have been provided access to protected varieties for conducting of experiments or the research or use of the variety as an initial source of variety for the purpose of creating other varieties. So that is referred as a researcher's exemption. So researchers are exempted for using that material for conducting their experiments for developing new things. In case of registered variety registered variety is required as a parental line for commercial production of a newly developed variety, then authorization from the breeder of the registered variety is required. Then coming to breeder's rights, the certificate of registration for a variety issued under this act shall confer exclusive right on the breeder or his successor or his agent or the licensee to produce, sell, market, distribute, import or export that variety. And IPR has accorded with the registration of a plant variety which is called as plant breeder right PBR. Then what are the advantages? It will encourage the private research resulting in number of good varieties, increases the competition, and the Indian farmers and seed industry will get access to foreign materials from the countries where IPR laws are already enforced, and more genetic variability will be available to the Indian plant breeders, as a result of which they can develop the better varieties. Then disadvantages of the plant breeders: it will encourage monopolies in the genetic material for specific traits, as witnessed in case of PT cotton, and the holder of PBR may produce less seed and then demand to increase the prices for making more profit. So this may be a threat, and genetic diversity will be reduced because land races will go out of use, as happened in case of cotton, and it will inhibit free exchange of material is inhibited and foster unhealthy practices, and the farmer's privilege to use his home seed will also be threatened, and the PBR may increase cost of the seed which the poor farmer may not be able to afford, and thus it will only help the rich farmers, which also happened in case of cotton, where government was forced to intervene in this issue and curb the increase in the prices. Then farmers' rights. Indian PPVFR Act is unique in the world in the sense that it has given some rights even to the farmers for their contribution in the economy, conservation of genetic resources, and also for the development of new varieties. So the farmers' rights are like this: the farmer's right to register the traditional varieties, so which are already in the public domain, which are really working well, and which have been carried generation to generation. They can go for registration of that traditional varieties as a farmer's varieties. Farmer's right to sell the seed, so which is produced by them, the farmer's varieties especially, or the traditional varieties. However, they are exempted from selling the labeled seed. Then farmers' right for reward and recognition. So the reward and recognition, because the farmers have been actively involved in conservation of the genetic resources and development of the new varieties, there was a common fund which was the gene fund which is raised, which from which the rewards have been constituted the farmers. And also PPVFR authority has constituted Kisan Puraskar awards, and the recognition will be as Plant Gene Savior Community Recognition Award, which have been constituted from 2007 onwards. And farmers' right to claim the compensation of the protected varieties if he is going for protected variety cultivation. If there is any kind of reduced levels of outcome of that protected variety as prescribed or as promised, then he can go for claiming a compensation. Then protection against innocent infringement. This happens regularly with the farmers because farmers do go for cultivation of their crops, and they also do some kind of exchange of the seed material sometimes. Knowingly or unknowingly, farmers use the covers which are labeled, which were brought by them, or sometimes which are uh, left outside, something like that. And knowingly and unknowingly, these have been used by the farmers for storage or for distribution of the seed. So this is an innocent activity of the farmers. If it is proven to be innocent, these farmers are exempted from any kind of legal action. Then farmers' right to information. So that's also very important. Though farmers are given privilege if in case of any kind of legal activity, legal what you call uh, prosecution happening at that point of time, they are given support not to pay any kind of the fees to the court, something like that. Then benefit sharing for the use of biodiversity conserved by the farming community. So this is the first important. This is the most important thing, which was also given under various international organizations as well. So for conservation of the biodiversity conserved by the farmers, there are some unique things which were which have the specific characters. When these are used by someone else for commercial activity, the benefit sharing should be given to the farmers. This was also prescribed in PPVFR.